Good afternoon, all, and thank you for joining Amanda and I to celebrate 10 years of the Equality Act as part of our Equality Act series. We'll be looking at two lines of authority relevant to direct discrimination and harassment. We'll take one case each. I will be dealing with direct discrimination and how the law has considered the burden of proof, along with the drawing of inferences in discrimination cases. And Amanda will be looking at the harassment provisions under the Equality Act and the knotty problem of third-party harassment. And thereafter, we'll have discussion and question and answers. We don't have very much time, so I'll try not to drag on too long. So if I could have the next slide, please. The Equality Act received the royal assent on the 8th of April 2010 and came into force on the 1st of October 2010. It was said to herald a new beginning in equality law, and many practitioners at the time were infused about the direction of travel. And for the most part, the Equality Act has done what it set out to do. The twin aims were to harmonise the legislation and simplify, to harmonise and simplify the legislation and strengthen the Equality Act in various aspects. For example, it strengthened the positive action duties under section 158 and 159, and also the socio-economic duty. Unfortunately, that hasn't been implemented, nor has the dual discrimination aspect of the Act under section 14. But more troubling, the third-party harassment provisions and the formal questionnaire procedure were repealed by the coalition government in 2015. So many view the last 10 years as a missed opportunity. Next slide, please. And so the structure of the Act, Part 3 deals with services and public functions. And that also, you also need to be mindful of Schedule 2 and Schedule 3. And it makes discrimination unlawful. It also prohibits against harassment, victimisation, and also for person when providing services, whether that's be goods and services and public, the exercise of public functions. Part 4 of the Act deals with premises. It makes it unlawful to discriminate, harass, victimise a person when disposing of property or the management of premises. And Part 5 of the Act deals with employment, which is the more common part. And also Part 6 deals with education and makes provision for outlawing discrimination in education and higher education. And also Part 7 deals with associations, and it makes it unlawful for associations such as private clubs, members or political organisations to discriminate, harass or victimise members or guests. And next slide, please. Now, the definition of direct discrimination is occurs where A discriminates against another, B if A treats B. A discriminates against another B if, because of a relevant protected characteristic, A treats B less favourably than he treats or would treat others. And direct discrimination includes perceived and associative discrimination. So, for example, if someone mistakenly believes that an applicant for a job was black because they had an African-sounding name, but in fact they were white and married to an African, that would be sufficient to be caught by the Act. So that individual could bring a claim for direct discrimination because the discriminator mistakenly believed she was black African or of African origin. Likewise, associative discrimination, you can bring a claim for direct discrimination if it's because you're associated with another protected characteristic. Direct discrimination also includes any treatment based on stereotypes. So the obvious one being if there's assumptions made about one's capabilities because of their race or because of their gender, Next slide, please. And when looking at direct discrimination, you have to you have to show less favourable treatment and the reason why. And I've set out there the various cases. Under Section 23, you must compare like with like. So there must be no material differences between the relevant circumstances. And Shamoon is authority for the hypothetical comparator. So a tribunal can, if there is no actual comparator, then a tribunal can rely, or an individual can rely on a hypothetical comparator. And the case of Hewitt is quite helpful, because that says comparators can be appropriate even if the situations compared are not precisely the same. And it's a question of fact and degree for the tribunal. So if you don't have an actual comparator, you can use an evidential comparator to inform the hypothetical comparator. Next slide, please. And this is the line of authorities that I wanted to spend a little bit more time on. Many of you may recall the case of King and British China Centre, which predates the Equality Act, but certainly under the King guidance, it was enough if a claimant could show less favourable treatment and difference in status. That would be sufficient to shift the burden of proof. We then had Aigen and Yong, and we had the burden of proof directive, which influenced the amendments to the Sex Discrimination Act and the Race Relations Act at the time. And Aigen and Wong set out the standard test, and Madarasi was a case where the court said, well, actually, difference in status and difference in treatment is no longer sufficient to shift the burden. And what they said is something more is needed. Now, pause there. When the reversal of the burden of proof provisions came in, there was hope, much hope, that it would have a greater impact on the success rates in discrimination cases. That's why it was introduced. However, what we've seen over the last 10 years is where, under the King test, the tribunal's discretion, or the court's discretion, was largely at stage 2. So it was sufficient to shift the burden. Difference in treatment, difference in status was sufficient to shift the burden of proof. But a tribunal could reject a claim for discrimination even where the respondent didn't provide an innocent explanation, or if the explanation provided by the respondent was unsatisfactory. So what you've seen over the last few years is, following the reversal of the burden of proof directive, that discretion at stage 2 is no longer available to a tribunal. So if the tribunal finds that there is a prima facie case and the respondent's explanation is rejected, then the tribunal must find discrimination. So the net result of that is you now see much more flexibility and discretion being exercised under stage 1. Hence, Madarasi saying something more is required. And often it's difficult for a claimant to identify what that something more is. And Demand was a case that was Lord Justice Sedley, and he said that actually the something more that was required need not be a great deal. In some instances, it will be it'd be enough if there's a non-response or an evasive or untruthful answer to the statutory questionnaire. In other instances, it may be furnished by the context in which the act has allegedly occurred. You don't have to have a great deal. Unfortunately, we no longer have questionnaires. We do have the ACAS questionnaire, but that's not as robust as the previous questionnaire under the Act. Next slide, please. And the case, I think you may have gone one too many. Oh, no, maybe that one's missing. Let me just check. It should be the facts. You can't see that. That's fine. I should have it. I should have it here. Well, Reynolds concerned the case of Dr. Reynolds. She was 73 years old. And what happened in that case, there was a manager who made a report about Dr. Reynolds to the senior executive of the company. And as a result of that report, she was dismissed. And what the manager was concerned about is she had a way of working which the respondent didn't appreciate. So she would use a dictation machine. She wouldn't type her reports, and she would send things by post. She wouldn't use email, and the managers felt that was outdated and made all sorts of assumptions about her ability to undertake new tasks and grasp the modern technology. And it went to tribunal, and the claimant didn't argue or didn't bring a claim against the two individuals who gave the report. Excuse me. And the tribunal decided that the claimant has shown a prima facie case of discrimination. The burden had shifted to the respondent to provide an innocent explanation. And the tribunal was entirely focused on the motivation of the dismissing manager, rejecting the suggestion that he made age-related stereotypical assumptions about the claimant, being unable to change her workloads, her working methods, excuse me. The ET concluded that the reason the respondent terminated the agreement had not in any sense been related to age, and the claimant appealed to the Employment Appeal Tribunal, and on the basis that the Employment Tribunal failed to address the mental processes of all the relevant employees, focusing exclusively on the mental processes of the dismissing manager, and that was liable for found that the tribunal should have considered whether the mental processes of the manager who provided the report about the claimant's capabilities or the claimant's working practices. And that came before the Court of Appeal, and they found that the respondent was not liable for age discrimination because the dismissing manager was the sole decision maker and did not have any discriminatory motivation. And the two managers who provided the report to the dismissing manager, they would have been liable had Mrs. Reynolds brought claims against them or applied to the tribunal to join them. And Underhill, it was Lord Justice Underhill, in paragraph 36, his reasons were, well, it's fundamental to the scheme of the legislation that liability can only attach to an employer where an individual or agent for whose act he is responsible had done an act which satisfies the definition of discrimination. An individual employee who did the act complained of must himself been motivated by the protected characteristic. So in other words, because you have a situation where, let's suppose I'm motivated by sexist reasons, and I decide to bring I'm a manager, I decide to bring a disciplinary against my subordinate staff member because I believe she's not capable. And I make a report to the dismissing officer, and it's entirely false. And that the disciplinary manager dealing with the outcome then makes a decision to dismiss in good faith based on my discriminatory report. In those circumstances, after Reynolds, a claimant would have to name me as a discriminator and the person who made the decision to dismiss, which is unnecessarily complicated, it seems to me. And Underhill said at paragraph 36, I believe that it's fundamental to the scheme of the legislation that liability can only attach to the employer where an individual or agent whose act is responsible has done an act which satisfies the definition of discrimination. In other words, the individual employee who did the act complained of must himself have been motivated by the protected characteristic. Now, it seems to me there are some unintended consequences flowing from the Reynolds decision, because you will have to know who the decision makers are, and often the claimant won't have that information. And it seems to me that it encourages employers to mask or disguise the true identity of decision makers, knowing full well that it's making the employee or the employee's ability to prosecute their case much harder. And Denby is an example of that. If I can have the next slide, please. Sorry, I was talking away. If you could go on to 2 more. That's the one. Yeah, so Denby was a case where he brought a claim for sex discrimination, and he was suspended, and the suspended was lifted, and then a senior member of the Metropolitan Police reversed that decision, and we didn't know who that was, and you had 2 senior members of the police blaming each other. So because we didn't know the decision maker, we applied to amend, I think it was during the course of the hearing, and we said that either it was a joint decision or A was influenced by B or vice versa. And we succeeded, and in the EAT, the Met Police appealed against the tribunal finding. And this is what Mr. Justice Kerr had to say about the Sealfist decision. He said, the Sealfist decision should not become a means of escaping liability by deliberately opaque decision-making which masks the identity of the true discriminator. Where a claimant is for good reason unable readily to identify which individual is responsible within the employing organisation for an act of discrimination, the claimant may, as in this case, sometimes be permitted to amend during the hearing once the correct person is or persons are identified from the evidence. So that's a good example and a warning to claimants to make sure that you take steps to identify decision makers. And this applies across all of the provisions under the Equality Act. So if you are pursuing a complaint under Section 4 premises, well then Reynolds would apply, the same rules would apply. A more recent case is the case of Olacan and Serco, and this is where the employer tried to extend the Reynolds principle to the choice of comparators, and the EAT rejected that submission, and they said ET rejected the employer's submission that the existence of a different decision maker in relation to comparators' disciplinary proceedings would necessarily amount to a material difference for the purposes of identifying a comparator. So what they was trying to do in that case is say, well, actually, it was a different decision maker in relation to a statutory comparator, therefore, a Reynolds applies. And thankfully, that was rejected. But it just goes to demonstrate how the unintended consequence of the Reynolds decision and what attempts employers will make to exploit that. I think, next slide. I think that's me, and it's over to Amanda now.
Many thanks, David.
Thank you.
Yes, I'm going to deal with the issue of harassment under the Equality Act, which is section 26. If I can have the next slide, please. Like direct discrimination, it applies to all areas of the Act, so will apply to the other parts such as housing, education, goods and services. It also applies to the protective characteristics, all the protective characteristics, age, disability, gender reassignment, race, etc., except it does not apply to marriage and civil partnerships or to pregnancy and maternity. If someone has been subjected to harassment for either of those protected characteristics, then for pregnancy and maternity, you could rely on the sex provisions, and for marriage and civil partnership, you may be able to rely on the sexual orientation provisions. In addition, some parts of the Act exclude certain protected characteristics similar to the direct discrimination. So, for example, age is excluded from the section on schools, religion or belief, and sexual orientation are basically excluded from almost every part of the Act apart from employment and FE and HE. Next slide, please. Here I set out the definition of harassment, and it's important to remember when dealing with harassment that there are, in essence, 3 different types of harassment. We often, when we refer to harassment, are referring to the general harassment provision under section 26(1), which is that A engages in unwanted conduct related to a relevant protected characteristic. And that is the harassment that I'm going to deal with. But there's also sexual harassment where the unwanted conduct is of itself of a sexual nature. And the other provision, which deals essentially with victimization, someone being treated less favorably for either submitting to or rejecting conduct either of the sexual nature or that is related to gender reassignment or sex. In relation to all 3 types of harassment, the conduct in question and the provision to be applied is set out below, and it is the conduct must have the purpose or effect of 1, violating B's dignity, or 2, creating an intimidating, hostile, etc. environment. So there are alternatives. Either it must have the purpose or it can have the effect. If it has the effect, then there are further requirements that need to be taken into account, set out on the slide there, including the perception of B, other circumstances in the case, and whether it is reasonable for the conduct to have that effect. Unlike direct discrimination, the test for harassment does not require a comparator, and that is represented by the fact that it is conduct related to a relevant protected characteristic rather than conduct because of a relevant protected characteristic. Further, there is, like direct discrimination, no justification defence. If the provision can be complied with, then harassment is made out. A couple of tricky areas in relation to this provision. One is the issue of related to, which I will come to shortly, and the other is the nature of unwanted conduct. Unwanted conduct can be any unwelcome or uninvited conduct. It need not be overt. But there are some familiar grey areas, such as what to do about banter and jokes, particularly where someone has been a willing participant in that banter, maybe initially, and then finds that at some late future point, they are not, they start to find the jokes offensive, or where even where they were unwilling, they didn't complain initially, but then do eventually complain. Further, the other areas in terms of unwanted conduct that can be tricky is conduct that is initiated by the complainant, but then gets out of hand, or conduct that is otherwise in the public domain. And in relation to that, you have had cases regarding the outing of someone who's gay, who themselves have outed themselves to colleagues, and there have been arguments run that their sexuality is in the public domain and therefore they cannot subsequently complain of harassment if someone else outs them to another person. In relation to the issue as to whether the conduct is unwanted, HM Land Registry versus Grant, a Court of Appeal decision, Elias J said, the context in which it is given is always highly material. Everyday experience tells us that a humorous remark between friends may have a very different effect than exactly the same words spoken vindictively by a hostile speaker. The issue around unwanted conduct and what is welcome or unwelcome remains a very problematic area in relation to the definition of harassment. As I said, the other problematic area is the issue of related to. And if I could have the next slide, please. Related to is a significant change, or a potentially significant change, to the Equality Act compared to the pre-Equality Act provisions. Before the Equality Act, that statutory test for harassment was on grounds of. This had been challenged as incompatible with the EU Equal Treatment Directive in relation to sex, as being too restrictive since it requires a causal link. The directive used the phrase related to, and therefore only required a connection or association. The EOC succeeded in therefore challenging the use of the words on ground of, and as a result, the Sex Discrimination Act was amended to related to. But the other provisions were not changed and therefore remained to be on grounds of. So, for example, the Sexual Orientation Regulations and the Race Discrimination Act remained, the definition of harassment remained on grounds of. And it was only when the Equality Act came in that the test for harassment was harmonised across all the protected characteristics to related to. And as David said at the beginning, that was the real advantage of the Equality Act, is it did bring all the strands of protected characteristics under a single umbrella and under a single test, because prior to that, there had been quite complicated case law as a result of the different wordings used by the different statutory provisions. Why does it matter whether we use on grounds of or as it is now under the Equality Act because of, as opposed to related to? It matters because the concept of related to potentially is wider than that of because of. It provides a broader context within which an employer could be liable for harassment. And examples given in the EOC case was, for example, using an offensive, obscene language in front of a group of male and female staff, i.e. both the male and females were being treated equally, but which was peculiarly offensive to women, or a claimant being unfairly treated by their manager who was jealous of their sexual relationship with a colleague, or a manager barging into a female toilet, but would equally have barged into a male toilet. In all those circumstances, if the test was because of or on grounds of, the claim could fail. But if the test is related to, it is connected or associated with the protected characteristic in question. The EOC code at paragraph 710 confirms that that is their view, that related to potentially provides a wider definition and can apply to situations where the conduct was related to, or even though it was not because of the protected characteristic. Next slide, please. The issue of related to comes into play when considering the issue of third-party liability. And before I go into that, a brief history in relation to where we were on third-party liability prior to the Equality Act. I refer there to three cases. The first in time is that of Burton versus De Vere Hotels. This is the Bernard Manning case and concerned two waitresses of Afro-Caribbean origin employed by the hotel, who were made the object of racist and sexually offensive remarks by the after-dinner speaker, Bernard Manning. The hotel was well aware of the nature of his act. The EAT in that case held that the hotel were liable because it caused or permitted the harassment to occur in circumstances that it could control, and therefore could have prevented or reduced the harassment. There was, the EAT said, no need for the claimants in that case to take the additional step of showing that the employer was affected by racial bias. That case was subsequently considered in the case of Pierce versus governing body of Mayfield Secondary School. This was also a third-party liability case and concerned a lesbian teacher who had been subjected to sustained campaign of homophobic taunts, abuse and harassment by the pupils of the school. The school, the employer, failed to prevent that harassment. However, the House of Lords in Pierce concluded that the school was not liable and expressly disapproved the reasoning in Burton. In particular, Lord Nichols stated at paragraph 35, with reference to the case of Burton, the hotel's failure to plan ahead properly may have fallen short of the standards required by good employment practice, but was not racial discrimination. With reference to the provision of harassment, he stated at paragraph 37, a fundamental feature of this aspect of the legislation is that attention is focused on the conduct of the particular employer, not the conduct of a reasonable employer. Further, the circumstances where an employer is liable for the acts of others are stated expressly in the legislation. It is not for the courts to extend the ambit of the discrimination legislation, however desirable this may seem, under the guise of interpreting the provisions which are unambiguously clear. And in that case, it was held, it was unambiguously clear that the motive had to be that of the employer, not the third party. The final case was the case of Conte versus Parking Partners. This was a race discrimination case because, of course, by that time, the situation had changed in relation to sex discrimination. And in that case, the claimant, a car park attendant, was employed by a subcontractor, was subjected to racial abuse by an employee of the residential development company to whom she provided car parking facilities. The manager to whom she complained failed to take appropriate steps to deal with the abuse. The EAT in that case accepted that inaction could constitute unwanted conduct, but that an employer could not be liable for the hostile environment created by a third party, even where that inaction made that environment worse, unless that inaction was itself motivated by the race of the claimant. These were all cases that were decided pre the Equality Act, using the test of on grounds of. The EOC case had held that third-party liability was not covered by the concept of on grounds of, even where the employer knowingly failed to take steps to prevent the harassment by others, but had suggested that it could be covered by the broader concept of related to. As I've already said, the cases of Burton, Pierce and Conte were ones that dealt with the test of on grounds of. So this immediately raised the question with the introduction of the Equality Act, whether the broader concept of related to under the harassment provisions could therefore permit third-party liability. In addition to that comment in the EOC case, with the Equality Act, there was an express provision introduced, which was that of section 40, subsection 2 to 4, providing liability on the employers for third-party harassment. And as David has already referred, this was subsequently repealed in 2013. So from 2013 onwards, we were going back to the position whereby harassment referred to the test of related to, but there was no express provision under the Act providing for third-party liability. I can have the next slide, please. So now we come to the case which has been decided under the Act, which is that of Unite the Union versus Naylard. And this is the case that considered whether third-party liability could be concluded in the concept of related to. It is also a case which has developed the area in relation to the concept of related to, and therefore has a broader implication than just those of third-party liability. The fact of the case is that the claimant was employed by the union as a full-time regional officer. She was subjected to a campaign of sexual harassment by two lay officers, used to be known as shop stewards. She complained about that. The union accepted that she had been subjected to bullying and sexual harassment, but they didn't discipline the lay officers, but instead made a decision to transfer the claimant to a different area in order to protect her. She therefore submitted claims to the Employment Tribunal for direct discrimination and harassment by both the lay officers and the employed officials for their failure, their inaction to do anything about the harassment, and their action by moving her to a different area. The ET made no finding that the employed officials themselves were consciously or unconsciously motivated in their inaction or the decision to transfer the claimant. And that becomes relevant when we see the decision that the Court of Appeal gave in relation to this. The ET decided that the union was liable as principal for the action of its lay officers as agents, and the union was liable as an employer for the action and inaction of its employed officials. Next slide, please. The EAT agreed that the union was liable as principal for the action of its lay officers, but concluded that the union was not liable as an employer for its employed officials. So now we come to the Court of Appeal. They again agree that the union was liable as principal for the action of its lay officers, and you have there the section under the Equality Act, section 109, which makes that provision. And that is a section, again, which applies not just in the employment sphere, but can also apply to non-employment. In relation to claim for direct discrimination, the Court of Appeal held, with regards to the actions of the employed officials, that since the reason for that action or inaction was not because of her sex, but because the relationship between the claimant and the lay officers had broken down, there was no direct discrimination. So this comes back to this whole area of what was the employer's motive, or the motive of the decision maker that David was referring to under the claims for direct discrimination. And it's no surprise that the judge in relation to Naylard was Underhill, who was the same judge who was gave the decision in Reynolds. In relation to the claim for harassment, he also held that the union was not liable for the actions or inactions of the employed officials because related to did not cover the cases of third-party liability. The union, he said, could only be liable if the protected characteristic formed part of the motivation for the action stroke inaction. Next slide, please. His reasoning in relation to the issue of harassment was on 3 points. First, he said that the EC directive did not impose third-party liability. And there has been a subsequent case that I will refer to in due course of Besson, which reached a similar conclusion. Secondly, that the express provision in the EA on third-party liability had been repealed, and we had seen there that we had this section 40, subsection 2 to 4, which had been initially part of the Equality Act, which was repealed in 2013. And Underhill stated in relation to that, that since that had been expressly repealed, it therefore suggested there was no intention for third-party liability to be provided under the auspices of the Equality Act. And thirdly, he held that contrary to the views of Burton, the judge in the EOC case, the concept of related to is not sufficient to place liability on an employer for third-party harassment, where the employer is innocent of any discriminatory motivation, even if they could have prevented the harassment in question. And that is the significant finding that Underhill made in relation to the case of Naylard, and that has wider implications for the test of harassment going forward. Next slide, please. Underhill acknowledged in his conclusion that as a result, employees have no protection from third-party liability, but stated that it is a matter for Parliament. It is a conclusion that affects non-employment cases as well as employment cases, since the test for harassment is the same for non-employment cases as it is for employment. It did accept there is a crack, I suppose, that in some cases, it may be possible to argue that the employer's or the service provider's actions or inactions were motivated consciously or subconsciously by the protected characteristic in question. And in the case of Naylard, Underhill declined to comment on whether a distinction could be drawn as to a situation where an employer was culpably inactive, knowing that the employer was subject to continuing harassment, as in the Burton case, as opposed to where an employer had no knowledge. But he stated that he believed the employer would not be automatically liable in either situation. The case of Naylard has been considered in three further cases, three very recent cases, that of Prasad, Besong, and Kopik. Prasad was not a third liability case. It was a consultant cardiologist who was subjected to an anonymous letter sent to 5 recipients. The contents of the letter itself were not related to sex, but related to her practice. The Employment Tribunal found that in relation to 2 of the letters, the recipients were not in compliance with the sender's professional obligations. However, the Employment Tribunal failed to consider the motivation of the sender for sending the letter to those 2 recipients. And as a result, the EAT remitted the case back to the Employment Tribunal to make a decision as to whether there was motivation. So picking up on the motivation question identified in Naylard, Prasad had failed to deal with that, and therefore it was referred back. What I think is interesting in relation to the case of Prasad is that His Honour Albach made the following comment in relation to the issue of related to. And he said this: any conduct which is because of sex will also be related to sex. However, conduct may be found to be related to sex even though it is not because of sex. Pinning down, however, the outer limits of what sort of thing it is that would, in law, count as sufficient to make conduct related to sex or any other protected characteristic, even though it might not in the given case be because of sex, is a little trickier. There's agreement in the authorities that certain examples of scenarios, one way or another, cross the line. See in particular the discussion in Naylard of paragraph 56, and those are the 3 examples I referred to earlier. But teasing out or distilling a test of what exactly it is that makes such conduct related to sex is not, I think, so straightforward. And that is a comment made as recently as 2019, and I think we are still no further forward in understanding what are the parameters or the outer limits of what is meant by related to, as opposed to because of a protected characteristic. The second case that has considered Naylard is that of Besong. This was a case of a claimant, a Black employee employed by the trust as a mental health nurse, who was assaulted by a patient with a long history of racially abusive behaviour towards Black members of staff. the ET found that the trust had failed to ensure reporting of all incidents contributing to a hostile environment in which racial abuse was more likely to occur. However, even though this is a situation where the ET found that the employer had contributed to a hostile environment, the EAT held that it was not sufficient, that even though the unwanted conduct had occurred, and even though it was foreseeable, the unwanted conduct had to be related to race before it could amount to discrimination. Again, it made the comment that it accepted that third-party harassment had much to commend it, but that it was not covered in the law as currently drafted, neither EU law nor the law under the Equality Act. The final case I've referred to is that of COPEC. This involved the concierge at a block of flats managed by an employer who was subjected to 2 separate incidents of racial abuse by delivery drivers. The employee resigned and claimed constructive dismissal after the employer failed to take the harassment seriously and prevent it from occurring. The EAT, the harassment claim, the direct discrimination claim failed at the ET, but the harassment claim succeeded. The EAT, however, overturned the ET's decision because the Employment Tribunal had not considered NAILARD. What I think is interesting in COPEC is the EAT refused to substitute its own view and instead remitted the case back to the ET, stating that the finding that there was no discriminatory motivation in relation to direct discrimination did not automatically lead to a conclusion on the same facts that there had been no discriminatory motivation under harassment provisions. The prism of the law relating to direct discrimination is different to that of harassment, and that is a reference to the difference in the test being because of or related to. So COPEC, whilst the flow of the cases post-NAILARD seemed to be suggesting that there was a bringing together of the tests of under harassment related to and direct discrimination because of, I think COPEC is a good reminder that the tests are different. The problem we have as practitioners is the courts are far from clear as to exactly what that difference is and the parameters of that difference. So I think now it's open to questions or discussion. Has anyone got anything they want to contribute or want further questions about? David?
Is there any questions?
I think one of the things I wanted to say about, I mean, listening to both David's presentation and my own is, I think it's quite interesting how this whole issue about employer motivation permeates the equality law, or indeed the discriminator's motivation, because it doesn't necessarily have to just be the employer. And that in both cases, the courts are quite keen to limit the scope of the discriminatory provisions to ones where there is a level of motivation in the acts that we're talking about. And whether it's at stage 1, as in direct discrimination, and of course the burden of proof provisions also equally apply to harassment, or whether it's in relation to harassment, motivation, and the reason why the employer acted as they did is being used to knock back discrimination claims.
Yes, I think you pointed out that Underhill has had, or Justice Underhill has had a large part to play in that. And I think certainly when one looks at the difficulties it is improving discrimination, and the whole point of the reversal of the burden of proof was to make that task easier.
Yeah.
Well, in that respect, it's hard to see how we've succeeded or improved, and I think it's far harder in many respects to prove discrimination. What with the combination of Madarasi and now Reynolds, and the requirement that the individual decision maker has to be motivated by the protected characteristic, you can see why it's harder.
Yeah, yeah.
And I think that the trick is to identify those individuals early and get the information early and pin the respondents down at an early stage and get your ducks in order, as it were.
Yeah. Well, the problem with harassment is it's not so much the identification of the decision maker, because you know who the decision maker is,
Yeah.
but with third parties, they're one step removed from the harassment that has occurred.
Yes.
And therein lies the problem.
Well, there's an interesting argument that watch this space, because I had a situation where there's a client he was harassed by a third party, and he complained to the well, perhaps I should explain. He was employed via an umbrella company with the respondent, so too was the discriminator.
Mm-hmm.
And there was individuals, employees, who also worked for the respondents. They was employees. Discriminator was a contractor, so too was the claimant. And he was racially abused. The employees didn't do anything to prevent it. When he complained, they interviewed the chap, apologised, but they allowed him to come back to work.
Mm.
And he then resigned because he felt threatened and he couldn't continue working. So that's quite an interesting. I might be speaking about that a bit more. But you could run an Article 14 point along the lines of Gillam, and arguing that the fact that there is no provisions or protection under Section 40, or what was Section 40, could be a breach of convention rights. So that's probably one way to attack it. But really, really interesting. The other point I would add, Basong, because they were given permission to appeal to the Court of Appeal, but I think it settled just before it was due to be heard, which was a shame because they was running all those similar arguments.
So maybe it's not the last word.
No, I don't think. No. I think the takeaway point from this talk is we need to be a bit more creative, and we've seen that with the use of the Human Rights Act recently in Gillam, and you've got the I forget the case now, the interim relief case that's now got permission to go to the Court of Appeal to include discrimination, race discrimination as one of the categories in is it Sodal? I forget Stora, I believe it is. So you're seeing that more and more. So maybe that's the takeaway point. We need to be more creative as to how we argue cases and attack points.
Right. Okay, we've got a couple of questions which are not really on this topic.
Right.
One is, are employers required to provide full disclosure of their decisions when the claim is brought against them? I think that is something that we could answer. The other one is, what do the public panel think about the Uber judgment? But that's going to be a completely different issue. But if you'd like to answer the first, that might be helpful.
So are employers required to provide full disclosure of their decisions when a claim is brought against them? Yeah. Well, they should do, but they don't. And often it puts a claimant in a very difficult position, because if you aren't aware of all the decisions that have been taken or the people involved in those decisions, then it's very difficult for you to particularize your claim. And often a respondent will then pray in aid of that and pretend that they're unable to respond. So I think you need to be persistent and make sure you pin down and identify the decision makers, and don't leave it to day 6 of an 8-day trial as what happened in Denby. Although we got the amendment, but it does make life a lot harder. It makes it harder for you to plan. I would suggest.
Okay, unless there's any other comments, contributions, or anything else you want to say, David?
Just on the Uber judgment, I think it's a fantastic judgment, and it certainly it just cuts through a lot of the previous dicta about the contract and it taking precedence, etc., etc. So I think it's a good judgment. It's helpful to claimants and should be considered in full.
Okay. Right. Well, I think we're going to thank everyone for attending and for listening to us. You know, in these weird times, wish we could see you, but hopefully at some point in the future we will be able to. But thank you very much, and we're going to sign off now, I think.
Thank you.
Yeah. Bye bye.